So now I'm going to get things going with Sugouri Batra, who will be discussing all the regulations and case law from the US.
About 10 years ago, before entering law school, I was hired to be in a music video for a rap artist in exchange for a verbal promise of $200. The day of the shoot, I showed up on time at the location, did what I was supposed to do, and was told to follow up later for payment. Afterwards, I followed up several times in various ways. Days turned into weeks, turned into months, and over a decade later, I still haven't seen that money. This story illustrates just one of the many pitfalls that can be involved in influencer marketing, specifically not having a written contract. After 10 years of experiencing all sorts of pitfalls, I now know how to better protect myself, my image, and my identity against various situations, ranging from something as basic as not getting paid to more advanced considerations like protecting my identity and image. Hello, Singapore. My name is Sugouri Batra, an IP attorney and influencer. For longer than I've been an IP attorney, I've been a model who expanded into pageantry and currently serve as ambassador for various fashion and beauty brands. I'm here to talk to you about influencing in America from my experience as an influencer. During this first part of our panel, I will cover the legal basics of influencing in America, starting with some definitions, US regulations and causes of action, and then briefly discussing my favorite, the right of publicity in the US, and wrapping up with additional considerations. During the second part, I will share some additional, more recent war stories and conclude with my number one solution. Although solutions vary according to the situation, I will share my ultimate solution at the end of the panel. So get comfy and tune in to learn. The dictionary definition of an influencer is a person who inspires or guides the actions of others. A person who is able to generate interest in something by posting about it on social media. To influence means the power to direct the thinking or behavior of others, usually indirectly. Although US courts have generally adopted a dictionary definition, the New York Supreme Court has specifically defined an influencer as a content creator who promotes, markets, and advertises products and services to their fans and followers. Using influencers to promote brands is nothing new, but with social media's rise, the types of influencers and methods of influencing are. Whether macro or micro or nano, all influencers influencing in the US are subject to the same regulations. However, the reach of these regulations according to the size of the influencer's following is something that is still developing. In America, the main body regulating influencers is the FTC, or the Federal Trade Commission. The FTC published its guidelines in 2009 and proposed updates last year. In a nutshell, these guidelines basically boil down to disclosure and honesty in advertising. If an influencer has a material connection with the brand, they must disclose this in a clear and conspicuous manner. A material connection can be a personal, familial, or other relationship. Even if you get goods for free, you must disclose. Disclosure, however, can be easily satisfied by using #ad or #sponsored. Essentially, it boils down to this. If you tout, you must tell. Influencers may also be subject to regulations by the SEC or the Securities Exchange Commission if promoting goods and services relating to securities, including cryptocurrencies. We have seen the FTC bringing action against individual influencers for failing to disclose their relationship with the brand that they are promoting. And the first ever of this type of complaint occurred in 2017. The selling of fake followers also falls within the FTC's purview. But actions brought by the FTC or SEC are not the only ways an influencer can trip into a legal pitfall in the US. There are many other causes of actions, both at the federal and state levels, available for and against influencers. In the US, we have seen a variety of federal causes of actions arising, for example, under the Lanham Act for trademark-related violations and Copyright Act for photo and music-related violations. For example, what happens when a brand steals an influencer's Instagram photos without permission? In one instance, an influencer sued for violation under the Lanham Act for false endorsement, while in another instance, same basic fact, an influencer sued for direct copyright infringement under the Federal Copyright Act. What happens when a brand and its influencers use music without authorization in TikTok ads? In UMG versus Bang Energy, the energy drink brand was sued for both direct and indirect copyright infringement by the music owner and publisher. There, Bang Energy argued that it thought TikTok already authorized the use of the music, but the court did not buy this argument and allowed the case to proceed on both direct and vicarious liability, denying contributory infringement. This case illustrates that a company may be held liable for the actions of its influencers. We have also seen an influencer be sued under the Federal Trade Secrets Act. The beginning of the end of this story, one of my favorites, occurred when the influencer broke up partnership with the brand via text message and then started his own brand of sauces. The brand, a locally beloved seafood restaurant, ended up suing the ex-brand partner for stealing its iconic butter sauce recipe. The influencer argued, including that all he did was influence, that exposure to the recipe was nowhere part of his, fell within his scope. And he also argued that the sauces he created were different, including because they were vegan. All these cases that I just mentioned have settled except for Bang Energy, unsurprisingly. But as a side note, the Bang Energy case is stayed following Bang declaring bankruptcy. In the US, we have also seen a variety of actions brought by or against influencers at the state level, including for unfair competition, false advertising, trademark infringement, civil theft, conversion, breach of contract, fraud, misrepresentation, and violation of privacy rights, including defamation and discrimination. What happens when an influencer doesn't influence as hard as contractually promised? This one is easy. We have seen at least a few cases of the influencer sued for breach of contract. Well, what happens when an online hater hates too much by harassing an influencer and consistently degrading her and trying to ruin her reputation? We have seen the influencer sue the hater for defamation. You may wonder what happens when an influencer sells personalized fitness classes but fails to actually provide the classes after taking everyone's money. Where the fraud is bad enough, we have seen the state step in and sue for deceptive practices. As we have seen, influencing in America can manifest an influencer as either the plaintiff or the defendant. Perhaps the single most important consideration of an influencer is how their identity and image are managed, including their right of publicity. Unlike in Singapore and the UK, the US does generally recognize the right of publicity or the right over one's identity and image. In the US, all states protect at least an individual's name or likeness, aka their exact image. Many states have also recognized protection for things beyond exact image, like mannerisms and attributes. In addition to federal and state level considerations, an influencer should also consider laws in the places that their endorsement reaches, along with platform-specific considerations. Finally, considerations for a rising influencer or a micro and nano influencer specifically should include their evolving image. For example, an influencer in the fitness niche may one day evolve into the foodie niche. Evolving values. For example, an influencer at age 15 or 16 may have remarkably different values than at age 30 or 35. Evolving platform policies. As we may know, social media platforms are constantly changing their terms and services. And finally, evolving legal rules. How courts interpret and define these issues are in its infancy in the US. This brings us to a close of Influencing in America. Thank you all for listening, and I hope I influenced or inspired at least one person in this room. Thank you.
Thanks so much, Sugouri.
Speaking of celebrities, we have our own, Sugouri. I'm not done. I'll come back, I promise.
So, on to more recent war stories that I had promised earlier. Starting about 2 years ago, I was hired to do a photo shoot for the launch of a beauty medical spa in Miami. I was hesitant to accept this work because beyond facials and brow services, they also provided Botox and filler services, services which do not align with my current values as an influencer. Instead of saying no to the whole project, I dealt with this by carving out a written exclusion in the contract that my photos are not to be used specifically to promote Botox or filler services. As a side note, the irony is not lost on me of using a model without any work done to promote work being done. Just last month, I was hired by a makeup artist to do an editorial photo shoot in New York to submit the images to various fashion magazines. After the shoot, the photographer posted a video on his Instagram using a soundtrack that included profanities. This also did not align with my personal image or values. So I immediately reached out to the photographer and requested that he change the song. I even proposed some songs, but these songs were all rejected because turns out none of these were trending sounds on TikTok or Instagram like the original track. Ultimately, we agreed upon a soundtrack. Both of these stories illustrate the importance of an influencer protecting their identity, image, and values. Thank you.
Clicker.
And Sugouri, then also, kind of standing out in a sea of influencers when there could be demands being made and the like, how do you manage that on a day-to-day basis in addition to your legal practice?
So I promised you all my ultimate solution at the beginning of the presentation, and here it is. As an influencer, make sure you take out your red pen and redline each and every contract or piece of paper that's given to you. Whether it's something as small as a one-page release or a 10-page contract, redline that baby up. My baseline for signing any contract that I'm given is that I just don't sign unless I redline. Do not sign unless you redline. Of course, unless you've already negotiated. Parallel to or underlying this solution is a need to really protect your own right of publicity, your image rights, and your identity. Your image is yours, and the things that may seem as small as, ooh, this soundtrack doesn't go with my vibe, or do I really want to be promoting Botox when I know my little cousins are watching it, and I don't even have the work done, just because everyone else is doing it. These things may seem small, but they're not. And don't do that to yourself. Don't minimize these things, because at the end of the day, over time, your values and image may change, but your core essence will not. Thank you.